on to something quite exciting. Kelly mentioned at the beginning, it's something I definitely know very little about. I know it's a bit of a buzzword, these NFTs and the metaverse. And certainly what it appears is that the IP world is now affected by the virtual world, and how it all pans out, and are you able to file in the virtual world, and how does it work, and with classes and so on. And it's becoming quite a hot topic across the world. So it'd be great to hear some insights from our panelists. If I can briefly introduce Wensel is a partner in our Cape Town office, a trademark attorney with lots of experience. He handles both prosecution and litigation matters, as well as portfolio management. And Darshan Woodley. Darshan's an associate in our trademark litigation team here in Pretoria, and he works with a range of various litigious intellectual property matters, both in South Africa and across the continent. So guys, up to you to educate us, please, and thank you for the presentation.
Thank you, Simon, for the kind introduction. Let me just get my slideshow going. Let's share this. Here we go. Let me know if you can see my screen.
Yeah, we can, thanks.
Okay, perfect. I'm going to be discussing the metaverse today, and my colleague Darshan is going to be dealing with NFTs. It's really a hot topic at the moment. There's a lot of buzz around it simply because it's so new and quite uncertain times at present. Let's see. So my screen has seemed to have frozen.
Yeah.
So what is the metaverse? The metaverse is a virtual reality which was created to mimic or model real world things and avatar and actions. Avatars are used to navigate this called parallel universe. It is essentially a virtual reality space, and it is now being designed to be as close as possible to the real world. Where is the metaverse located? Well, there isn't a single metaverse. It is not and linked to a specific country as such. There are many metaverses out there. And the application is intended to be universal. On your screen, you see examples of these universes that have been created. You can see the avatars walking around, interacting, and real-world objects being displayed. So interesting questions come about when dealing with the metaverse, such as who owns the metaverse? How is it operated? Well, the answer is simply that there is no single metaverse. Software companies develop and design their own metaverses, all of them with their own rules and regulations and central themed. Some of the metaverses that have been created so far have been created by Decraland, Minecraft, Sandbox, Axie Infinity, Facebook's Metaverse, and the African central one being Africa Rare. It's important to understand that the metaverse is not an entirely new phenomenon. It's been in existence for many years. It's just that we've taken this jump with the advent or increased developments in virtual reality to create an environment that is more realistic than it's been traditionally been. It's not been new because it's been used in the gaming spheres for quite some time. So the sudden hype about the metaverse is because it's becoming all the more closer to real world interactions. Property, tracts of land are being sold in these alternative universes. For instance, MTN recently purchased a tract of land in the African metaverse, Africa Rare. Because there's this push to make this universe closer to real world realities. There's the application of brand names and copyright, artistic works, which are being introduced into this virtual reality. Say, for instance, there's a Nike t-shirt or a Nike shoe. That product is being displayed and being offered for sale in these universes, and it is linked to real world currency. There is a fear of losing out in this new realm as such by businesses. Because the experience is designed to be as close as possible to real world actions and interactions, a lot of the same individual rights are finding application in these universes, such as, for instance, non-discrimination laws, non-sexual harassment, privacy issues. So why is this relevant from an IP perspective? Well, it essentially creates this new virtual marketplace where businesses can advertise their goods, offer it for sale. They can create tailor-made goods for these universes. It is essentially a new marketing medium which is adopted to generate additional sales parallel to real-world sales. In this metaverse, copyright funds application, there's potential for design rights, patent rights, and obviously trademark rights. From a trademark perspective, it's important to understand that it's not the physical real-world objects that are being sold, but rather it is software that models or creates this image of a shoe or a shirt or a cap, for instance. From a trademark registration perspective, that creates very interesting questions. So in which metaverse to register? There's no single trademark register dealing with the metaverse, which means that one still has to consider the territorial filing of trademarks. Some metaverses are restricted to a geographic region, for instance, Africa or North America, which would make it easier to file applications. But when a metaverse has universal application and is not restricted in consumer base, and you want to enter into that metaverse, then it creates real interesting questions about where to register the mark. Some of the classes currently being covered by businesses are classes 9, 35, and 41. For class 9, they cover downloadable virtual goods, essentially being software that feature clothing, a cup, a toothbrush, a hat, for instance, for use in online virtual environments. Class 35 is essentially a retail service offering which features these virtual goods being offered for sale or displayed for sale. Class 41 covering non-downloadable virtual goods featuring the specific items being offered for sale and entertainment services generally. The trademark classification system hasn't been properly amended or updated to really provide for a set category or a set classification of these goods, which is why businesses are being innovative or call it risky in trying to identify what the appropriate classes would be. On your screen, you've got an example of one such registration filed with the US Trademarks Office for the well-known Nike mark. So what are the countries currently being covered in the by businesses to find some protection in the metaverse? Well, the USA, European Union, China, the UK, and Australia. China initially refused to accept those applications on the basis, well, the world doesn't exist, it's artificial. But they've had a change of heart and have been accepting applications of late. The US is being protected not only because it is a first world country, which we anticipate will have more users of the metaverse, but also because some of the software companies will be located in the US and their servers might also be located in the US. Some examples of companies who have filed for protection is Wendy's. On your screen, you'll see an example of a proposed Wendy's virtual restaurant where you can buy virtual food. Here, Johnson & Johnson, Australian Open, Bobbi Brown Cosmetics, Acer, Amazon, Nike, and Adidas. There are some potential problems for businesses wanting to enter into this fray. Some countries require proof of use in order to obtain registration, such as the USA. So it creates difficulties in filing the marks defensively, and also of proving sufficient use in the specific country in order to obtain a registration. There's the issue of potential lack of bona fide intention to use a mark in that specific country. Non-use cancellation applications come up. There's also this potential for third-party trademarks to already be present in those territories. For instance, if a business has traditionally been trading in Africa or say Kenya or Nigeria, they've determined their market and they know their market is available in that country. But when you extend it to foreign territories, there's always this competing risk of a prime mark being registered in that territory. As an interim solution for businesses, we suggest that you consider covering classes 9 and 41, even if only for your main marks, and to use metaverse-specific language in those specifications. If the operations of the business will extend to the metaverse in the near future, possibly a year or two later, consider covering the main countries, foreign countries of interest. Those would be the countries from which the consumers would most likely come from, at least in the start, until the uptake is sufficient for other countries and consumers from other countries to actually catch on to this new development and utilize it. Africa should by no means be left behind in this journey or venture, simply because the developments and technological innovation currently taking place in Africa is significant. The access to the internet and developments which have been taking place the past few years just support that. There's definitely space for Africa to join on this essentially interesting and excitingly new world. Although it is exciting, there are some interesting questions which come up when dealing with enforcement or infringement issues. Where does the infringement take place geographically? Which country should a proprietor institute action in? How do you identify the infringer? It will only be a pseudonym in this virtual world. How can you track their physical location in order to institute proceedings? Can you approach the platform provider to provide details of the infringer? There are issues of aiding and abetting on intermediary liability from the software providers or platform providers. Lack of actual use in the metaverse could be a potential defect in the decision leading to cancellation of your registered rights. And then there's the issue of security for costs in litigating against being a foreign proprietor, litigating in other jurisdictions. Existing trademark protection does provide some assistance in countries which recognize similar goods or services protection. However, this is all new. It remains to be seen whether a court will hold that registration for clothing and footwear in class 25 would, for instance, extend to virtual clothing, essentially being software. There are certain theoretical and conceptual issues that come up in dealing with similar goods protection. It is hoped that it will provide some protection, but definitely not foolproof protection. From an enforcement perspective, it is anticipated that the similar rules will apply to how we currently deal with online infringements. It also being something that takes place on the internet. So one will look at whether the business advertising their goods in the metaverse, offering for sale, targets or reaches consumers from a specific country. Presumably, you would then be able to rely on the national registration in, say, Kenya to stop such infringing conduct. It is anticipated that similar enforcement mechanisms will be adopted by the various platform providers to how Twitter and Facebook, for instance, deals with their disputes. All of these social media platforms have dispute resolution mechanisms to deal with it on an informal basis. So the terms and conditions, which state specific rules dealing with it, and procedures for lodging these disputes. But they will still require proof of registration. And that is where it will become quite tricky and interesting to see how they deal with certificates being lodged for non-metaverse related goods, for instance, clothing and footwear, as opposed to certificates being lodged for metaverse-specific goods. I suspect that metaverse-specific wording will carry more weight with those persons deciding the dispute on an informal basis. Copyright considerations also come into play, because just as you will be able to buy a Nike shirt or a Gucci handbag, you will then be able to buy artwork, real artwork that is created only for the metaverse, or which potentially models real world artworks, existing artworks. The Berne Convention provides some good protection in that regard, in that it allows the universal application enforcement of such copyright. But the same difficulties still arise. For instance, ascertaining the identity of the infringer and which country to litigate. If the internal dispute resolution mechanisms are or will be adopted by the platform providers, will they accept this unregistered rights basis? A lot of countries, copyright comes into existence without registration procedures. Some countries require registration as a prerequisite for copyright to subsist in a work. Will they deal with it? Will they deal with it on the basis of a statement under penalty or perjury, for instance? Advertising will also become important in this virtual world. You will also have billboard advertising that you can do, or pamphlets, or pillar post advertising for that matter. And interesting questions arise as to what rules will then apply. How will countries enforce their own national advertising laws in this universe? And it will be very difficult for businesses to navigate that properly. One rule of thumb would obviously is that truthful advertising should be adopted, and advertisements should not take advantage of the advertising goodwill or business advertising goodwill of other businesses, for instance. But again, it will be very tricky to navigate this. Obviously, the various platform providers will have their own rules dealing with advertising, but because real world rights are being recognized in this alternative reality, it is anticipated that advertising would become a regulatory nightmare to try and navigate. Counterfeit goods will also potentially feature in this metaverse. I don't think for a second that the metaverse will be immune to or completely free of counterfeiting. But then it becomes a very difficult question about how do you analyze these goods. You will essentially need to have access to the source code creating the good to determine whether or not it's legitimate. How would you gain access to it? And the only way I can really see this play out is if the platform providers take a more proactive stance in enforcing the protective mechanisms that they put in place, and conceivably without the assistance of the platform providers, it will become very difficult to completely police or regulate this aspect. Traditional enforcement agencies, I don't think would have the appetite to enter into the metaverse and to try and deal with these issues, simply because they're overburdened and they have real world issues to deal with. Some of the commercial considerations businesses need to take into account when considering entering into the metaverse is to make sure that their goods are portable to another metaverse. Conceivably, consumers would not only want to live in one metaverse, but would want to interact into many other metaverses, depending on where their friends are or what exposure they want. And there could be issues around whether the software that is used to create a Nike shirt or Gucci handbag in one metaverse would be able to be put in a locker and transported to this other metaverse. So it's advisable that businesses make sure that that takes place, because if the goods are not portable, it will become less desirable for consumers to buy them. Businesses should scrutinize their licensing arrangements entering into with these platform providers quite carefully to avoid for any unnecessary restrictions on their IP rights, or to avoid sub-licensing rights automatically being granted to these platform providers. It is anticipated that this new platform, which they refer to as e-commerce, will replace traditional e-commerce, online retail, in the near future. It remains to be seen whether that's true, but essentially you will no longer be doing online shopping. You would log into this virtual reality, you would go to a store, buy your things, and either check them out as software items, virtual goods, or it'll be linked to a real world ASDA, for instance, and they can come and deliver the products to your home. So your entire shopping experience is virtual, and without needing to leave your house, you can still browse through the stores and still see the same items. Brands are embracing this new hype about the virtual world because it creates this new marketplace for them, which is again an additional marketing medium. They're hosting garden parties to display their goods and incentivizing potential consumers to adopt this new reality by issuing tokens to them, which they can exchange for real world products. Now, some of the other considerations to keep in mind is which metaverse to trade in. Do you want to focus only on the African metaverse, for instance, regional ones, or universal application? The advertising regulations that are in place in the specific territories that you want to enter into. Obtaining interim protection pending full-blown escalation to the metaverse by registering your marks in classes 9, 35, and 41. Existing copyright protection to ensure that your copyright assignment agreements and other related employment agreements are watertight to ensure that you own copyright in the works, so that when you are called upon to prove your rights in this metaverse, you are able to do sufficiently, because copyright will play a really important part in enforcement in this metaverse. Okay, that's it from me. Over to my colleague Darshan, who will take you through the very interesting world of non-fungible tokens.
Wensel, sorry, just before Darshan gets going, I see there's just one question, quite an interesting question I wanted to quickly throw at you guys.
Sure.
The metaverse brings in very interesting issues. Would you know from a global perspective what efforts have been made by IP bodies such as WIPO in assisting countries to amend their laws or incorporate metaverse issues likely to arise in the future?
It is so new, Simon, that really, I think that everyone was caught offside. With this, really, no one as far as I'm aware, made any advancements in terms of amending national laws or trying to accommodate the IP systems. IP has always been somewhat reactive in that approach, in that you would try and deal with it via the traditional mechanisms, as they've been dealing with online infringements in a number of countries, and then see if it doesn't fit it to then amend it retrospectively. For instance, I'm still waiting for the NIS classification to be updated with the necessary changes. And I suspect your first changes will come into play in the NIS trademark classification.
Yes, I agree. Cool, thank you. Right, sorry, Darshan, can you tell us about another complication, NFTs?
Hi, Simon. Thanks, Wensel. So the reason for including NFTs to this presentation is that the different facets of the Web3 revolution are all linked in some way. I'll touch on the interplay a bit later, but to start, simply put, an NFT is an acronym for non-fungible token. It's digitally stored asset in which the subject can vary from anything from media in between art, music, to real-world products. At its essence, NFTs are tokens that are used to represent ownership of assets, mostly digital assets. And if we think of currency, which is normal crypto or central bank legal tender, it's fungible in the sense that it's exchanged in a like for like or dollar for dollar. However, NFTs being non-fungible derive their value from the fact that there is no like for like. It's more analogous to a limited edition item, a one-of-a-kind shoe or a one-of-a-kind artwork that's essentially stored digitally, or you could get the real world product. So then we get into like, who are the minters and what is minting an NFT? anyone can be a minter of an NFT. Now through NFT marketplaces online, it's made it so much more easier to mint an NFT. All that's required is that you have a crypto wallet, and certain fees are paid to the NFT marketplace to facilitate the minting of the NFT. It usually just entails converting digital data into crypto collections or digital assets that's recorded in the blockchain. The digital files or the products will be stored in a distributed ledger or a decentralized database, and it cannot be edited, modified, or deleted. There has been talk of it being amended, but it's not really easy, and it's not easy for the person that's off the blockchain to access it or read. So then we get into what is blockchain technology, and NFTs are underpinned by a blockchain technology. It's generally Ethereum blockchain, and its blockchain is essentially a digital ledger or record of transactions. And in the context of NFTs, it records transactions involving the purchase, the resale of the NFTs, as well from the minters to purchasers. The next consideration to take into account is a smart or digital contract, and this is based in the underlying blockchain technology. It regulates the functioning of NFTs, from verifying ownership, recording subsequent transfers in the secondary market, and it can even facilitate automated royalty payments to the NFT owner or the minter in the event of a resale. Where can you buy an NFT? NFTs are bought online and sold in NFT marketplaces. The most prevalent ones are OpenSea, Axie Marketplace, and Rarible. We've also seen a switch to sort of in-person auctions as well. A prominent wine estate in South Africa where rare vintages of wine were sold basically transferred NFTs to the people that purchased the bottles of wine to verify their ownership. And this is quite interesting because we could see more of this in the coming months as more companies and creators start entering the NFT space. To buy an NFT, prospective customers or purchasers need to set up a digital wallet and make the purchase using cryptocurrency. Simply put, anyone can access the NFT marketplaces, and you can own it provided you can afford it. Some of the prices have been quite hefty, but they are available to everyone and anyone. There's certain factors that make NFTs valuable or attracts value to it. You'd look at stuff like the artist, the uniqueness of it, the relevancy towards pop culture, history, and normal culture. But there's two aspects I want to touch on here. That's utility and security. Utility being that other than being digital assets, they have some sort of usefulness, or they can be used as collector's items, such as baseball and basketball cards. But it's more of that. It becomes more valuable to the purchaser when they can actually use it for something. So NFTs sometimes include the utility of access, and this is quite interesting because it touches on Wensel's aspect of the presentation regarding the metaverses or many metaverses. Users could trade NFTs between each other, sort of like to sell tickets to gain access into special events or concerts or digital concerts. So that could be something that an NFT could be used for as well. And that's sort of touching on the link to the metaverses, as Wensel explained. So for example, there's a popular social media influencer by the name of Gary Vee, and he has digital collectibles that include access to future special events that's hosted by him. And it also enables the purchaser to have one-to-one sort of a meet and greet with him and to possibly discuss business ventures with him as well. So this becomes very it becomes like a lot of people want it, basically. Other NFTs are used as gaming assets, which can be traded or used in video games. As Wensel also mentioned, the metaverse has previously been used in the gaming sphere for quite a number of years, but it's only really jumped to the forefront in recent times, much like NFTs as well. NFTs have been around since just before 2017. There was some activity on it, and even before that. Another consideration that NFTs attract value to, or one of the factors, is that NFTs have several built-in security features, makes them more valuable. And we've discussed this in the blockchain technology, but this gives you a secure asset, verifying ownership in the ledger and in the blockchain technology, which is a digital representation of a normal ledger. And as the NFT is resold several times, the chain grows longer and it becomes more valuable. So in addition to NFTs being transparent and open for inspection for anyone in the blockchain, this means that everyone has access to information about a particular NFT, which helps create trust in its value. So a few people have asked if NFTs are the future of art and collectibles. They've become very, very popular with artists and musicians and other celebrities because it provides creators with a different medium to selling their works and art and taking it to a different market that might not have been there previously. There is no middleman, and the factors that I previously mentioned can have some sort of influence to drive up the price of their works, which ultimately wouldn't happen in a normal gallery. There can also be automated royalty payments, as I previously mentioned, embedded in the blockchain technology as well. And I'll discuss this more in detail below. But these are some of the reasons why we think that it could be the future. But however, they're ultimately controlled by market factors, and the NFT market isn't as stable. So it's difficult to predict what might happen in the future. So that was just a high-level overview of NFTs, and now we're going to get into more IP-related issues. Wensel's also touched on this in his metaverse discussion, but the same sort of considerations apply to litigation, transfer of IP rights relating to NFTs. So when we consider assignment of rights and ownership of IP in the underlying work of NFTs, it's in the general course not transferred to the purchaser of the NFT unless it's embedded in the smart contract or it's otherwise agreed upon between the parties separately. If the smart contract contains or makes provision for the assignment of a registered trademark, the question arises, would this comply with the requirements for valid assignment in South Africa? Another question that comes to mind is how would we record it? How would we record it at the registry, and does it strictly meet the requirements of being in writing and signed by or on behalf of the assigner to be a force of effect? For now, it may be best for people or parties to conclude separate agreements in this regard regarding assignments of IP when transferring NFTs from the mint to the purchaser. Another consideration is jurisdiction, which Wensel has already touched on. It's also unclear where we would institute formal proceedings. The location of the minter, as well as the NFT marketplace could be a factor. Wensel's touched on security for costs and proceedings if instituted in South Africa. And at present, it's difficult to locate the minter, as they may be operating under various different online aliases. However, marketplaces such as OpenSea have indicated that they will forward takedown notices that's filed through their sort of procedure. It'll be forwarded to the minter, providing details of the complainant or the entity applying for the takedown of the NFT on the marketplace. And in this way, the minter might possibly get into contact with the complainant, and there may be a way for a marketplace to also provide this information in light of contemplated formal proceedings. There's been a recent case involving copyright in China around the Fat Tiger cartoon, and the comic image shows a fat tiger receiving a vaccine shot. The image was actually minted into an NFT using the same watermark that the artist left on the image of the comic. The proceedings were brought against a Chinese NFT marketplace called Bigverse, and the case centered around the NFT platform's intermediary liability and its obligations. The court ultimately found in favor of the copyright owner and made it clear that a transaction involving an NFT digital work is subject to the copyright owner's right of information network under PRC copyright law. As it was a Chinese NFT marketplace, it fell within the jurisdiction of China. But it will be interesting to see cases like this going forward in South Africa. Another consideration as well as are the parties, citing the parties. As I previously mentioned, it could be possible through NFT marketplaces to obtain contact information the mint of the NFT and citing the NFT marketplace as a second respondent or second defendant in any action or application that may be brought in South Africa or Africa for that example. The recent Fat Tiger Chinese case was only brought against the relevant NFT marketplace. So it was only brought against Bigverse, and it didn't cite the minter of the NFT in the proceedings. The only issue with this is that the NFT is removed from Bigverse, which is the NFT marketplace, but the minter could ultimately upload this onto any other NFT marketplace, perhaps even a bigger one such as OpenSea or Rarible. As we've previously mentioned, the NIS classification system has not been updated to provide for the classes and sort of proposed specifications for goods and services regarding the metaverse and NFTs. So this is our sort of speculation of what the proposed specs could be. So we have various classes that may be of interest. One would be class 9, class 35 as well, class 36, class 41, 42. It would be interesting to see when the NIS classification will be updated to provide for this. It has been updated to provide for cryptocurrency and related services. So hopefully a change will come soon, and in that way the metaverse and the NFT space will be provided for. And when discussing prosecution strategy, it'd be much better to have certainty with filings. So now jumping to infringement, there's been no decided case law in South Africa yet regarding NFTs. Although trademark infringement proceedings appear to be a viable strategy in the enforcement of a registered trademark, the liability may largely depend on whether or not the trademark is registered to cover NFTs, digital assets based on the blockchain, or similar goods or services. So based on the principles of trademark dilution, it's conceivable that infringement proceedings may be based on a registered well-known trademark, even if the trademark's not registered for NFTs or digital assets. Relying on this provision, the considerations regarding similarity of goods and services and other provisions, like I mentioned above, will not apply. And so this cause of action would likely succeed if the unauthorized use of the mark through an NFT would negatively impact the distinctiveness, the commercial value, or even the advertising value of the well-known trademark. However, one must be mindful of the wealth of evidence required to sustain this ground. For the time being, it will be interesting to turn our focus to a few of the ongoing international cases involving NFTs, and it will be really interesting to see the decisions that come out of that. The next aspect to consider is licensing and royalties. So purchasers and creators of NFTs should remain wary of issues regarding ownership and licensing and assignment of intellectual property rights. In the normal course, as I previously mentioned, the ownership in the underlying asset will not be transferred to the seller unless it's contained in the blockchain or a separate agreement is concluded. There have been instances regarding sales of NFTs in marketplaces where specific IP rights have been licensed to the purchaser from the creator or the minter. So the purchaser has been able to commercialize the NFT up to a specific amount, and thereafter the normal considerations will apply. The licenses can be embedded. The terms of the license can be set out in the blockchain or agreed separately. For the purchaser, this means that its use is only going to be very limited. It will largely only be able to make personal use of the NFT in their digital wallet. And I'll touch on this when we chat about blockchain domains and digital wallets. And possibly the only other right that the purchaser will have is to advertise the NFT for resale on the secondary market. The secondary NFT market is quite booming. So in light of the above, one must assess whether smart contracts can aptly cater for licensing of IP rights or the transfer of ownership. The embedded code or the smart contract it's difficult and it's expensive to amend once the NFT has been minted and it's been purchased and resold. So perhaps a separate license agreement between the parties are a better option for the time being. And in South Africa, as many on this call may know, there are benefits to recording the licensee in the register. A recorded licensee is referred to as a registered user. However, merely concluding the license in the smart contract embedded in the blockchain will not afford the parties the necessary protection. And in terms from a copyright perspective, if the intention between the mint and the purchaser is an exclusive license, then it must be in writing and signed. And supposedly the minter or the rights holder has to be the person that signs it. But if it's contained in the smart contract, it would be difficult to ascertain for third parties. So once again, a separate agreement is probably better to be concluded between the parties. I've mentioned previously that automatic royalties in terms of NFTs are payments to the original NFT owner. It's made on all subsequent sales. And it's a predetermined sort of cost by the minter once they've minted the NFT. The royalties can then be tracked, or all royalty payments can then be tracked and recorded on the blockchain for each subsequent sale, and it will eventually go back to the minter. But once the blockchain smart contract terms are created, the royalties can then just occur automatically. Wensel's already touched on copyright, and it's more or less the same. The interesting development that's come about recently is blockchain domains. And a blockchain domain is similar to a traditional domain, but there may be many similarities, but they're vastly different. If we use Adams and Adams's domain, traditional domain, for example, it's adams.africa. If it would be a blockchain domain, it could be adams.eth or adams.crypto. Essentially, a blockchain domain does not utilize a DNS server to link an IP address. Rather, it links to an address on a blockchain via an NFT provided by a blockchain domain service. A blockchain domain name is a specific crypto that may store cryptocurrency and NFTs. The owner of the crypto wallet linked to the blockchain domain. Sorry, I just had to change slides. The owner of the crypto wallet linked to the blockchain domain may take additional steps to point the background or point the blockchain domain to a separate website that's peer-to-peer internet system or the traditional internet. At present, the largest blockchain domain naming services are Unstoppable Domains. They offer various blockchain domains that are top level, so including .crypto, .nft, .bitcoin, and others. And Ethereum name services offering domains with the top level domain of .eth. So the critical difference between traditional domains and blockchain domain names is blockchain domain names fall outside the ICANN traditional DNS system, so they're not subject to any DNS-related rules that are in place to protect brand owners, such as procedures through UDRP and WIPO. So once a blockchain domain name is distributed to an owner or the registrant, only that owner may transfer ownership, and the blockchain domain naming service is not entitled to transfer the blockchain domain to another party. Enforcement issues are a problem for, as previously mentioned, regarding blockchain domains. There's no sort of internal procedures through domain naming service providers. It falls outside the ICANN system, and brand owners are very limited to how they can enforce their rights in this new space. Purchasing and minting the blockchain domains may be an option for brand owners, but due to countless variations of brand owners' trademarks within large trademark portfolios, it's almost impossible to purchase all blockchain domains. That may be an issue for brand owners. The same obstacles in bringing litigation for unauthorized use or the unauthorized domain name or blockchain domain name still applies for the metaverse and NFTs, in that it's difficult to trace the domain registrant because the blockchain domain naming service will not provide that information, and there isn't a central system that we can go through like a Whois search, for example. Another way that brands should look at enforcing their rights is start looking at alternative ways. So utilizing takedown procedures on NFT marketplaces is an option, as blockchain domain names are sometimes advertise for sale through the NFT marketplaces, and keeping an active monitor on the NFT marketplace would definitely be able to combat against the registration of that by someone who's going to misuse the domain, or that's anyone but the rights holder. Rights owners should consider also purchasing blockchain domain names that incorporate their primary trademarks rather than going deeper into their trademark portfolio. But some of the blockchain domain naming services have already registered various domains that cover many well-known trademarks. There was a sort of grace period for a few months where rights holders would be able to approach the blockchain domain naming service and obtain registration or purchase those blockchain domains. The grace period for one of the blockchain domain naming service has since passed. So monitoring the NFT marketplace could be a good strategy for now for brand owners. I've also touched on this previously, as NFT platforms have procedures for takedowns. OpenSea has a procedure already, and I've mentioned that they forward the takedown notices to the minter of the NFT as well. And this is a way to perhaps get in touch with the minter and ensure that the same NFT is not uploaded on a different NFT marketplace. So at present, there's some issues regarding anti-crypto sentiments in Africa. The central banks in Nigeria and Kenya previously issued anti-crypto sentiments and policies. For now, there appears to be a push to regulate crypto and in the virtual asset sphere and in Nigeria. Time will only tell how the sentiments and potential regulation will affect African crypto markets. Locally in South Africa, there are also regulations expected shortly. There's another interesting facet for firms to consider is I've noticed that there are watching services available for watching NFT marketplaces. At present, as some may know, that our firm already maintains a watch in the domain name space. So this may be an interesting offering to clients throughout to immediately issue takedown notices, perhaps on NFT marketplaces. So I've touched on this when I just started, but there's an interchange or a link between NFTs and the metaverse, and essentially NFTs enable the transactions that drive the metaverse. So Wensel touched on AfricaRare's African Central Metaverse. It's titled Ubuntu Land, and large South African corporations have already purchased virtual land in Ubuntu Land, and the NFT is used to back up the proof of ownership in this title of the property or space. And NFTs facilitate the trade of virtual products as well as real world products between users or between business and users in the metaverse as well. There's virtual galleries in the metaverse that will display various NFTs of artwork, be that digital or real world artwork. So this really all ties in because your blockchain domain would store your crypto wallet, which would have NFTs stored in them that can be utilized in the metaverse. And the other way around is that NFTs can be used in the metaverse. The relevance to Africa is that it gives African artists and creators, as well as businesses, the opportunity to reach a global market, a market that previously may not have been accessible to them. There's no agents or intermediaries involved. There's no middleman. It makes it much more profitable for African creators and businesses. The rights of African artists and creators are also protected, as evidenced in the blockchain technology, and automated royalty payments will constantly happen. So the African creator or artist will not lose out on subsequent sales. On your screen now, we're looking at two prominent pieces that have been sold recently. The first here is Osinachi, a digital artist at the forefront in Nigeria. And the second is by Young Kev in Kenya. These artists are at the forefront of digital art at the moment in the African continent, and there's many others together with them. Osinachi started working with the digital art from around 2017 and now is able to be propelled to the forefront of the African digital art scene after the hype surrounding NFTs. And we are seeing many artists ride the wave and mint NFTs of their own around Africa. And it's extremely beneficial to artists, as I previously mentioned, to retain rights and receive automatic royalty payments. Actually, whilst scrolling through LinkedIn last night, I stumbled across an article published by WIPR with the headline, "Issuers misleading purchases over IP rights and NFTs, more legal documents setting out ownership terms are needed, and more than $118 billion worth of NFTs were traded over Ethereum over the past 12 months. Despite concerns regarding enforcement in the NFT space at present, there are definitely benefits to creators as well as brand owners worldwide. Some high-end fashion labels or brands have been minting NFTs to verify ownership of a real-world item, such as shoes and clothing. And it's clear that these NFTs have been selling for large sums of money or crypto. So it's a very interesting space to be in and to be monitoring developments. And at present, even though the waters remain untested from an African context, when we speak about enforcement and protection of IP rights in relation to NFTs, hopefully there's some certainty on the horizon for everyone on the African continent. And in light of the amounts being traded on marketplaces, the future of NFTs sure looks bright. Thank you, everyone.
Many thanks, Darshan. Great presentation, and yes, food for thought. Lots of stuff going on in a space that many of us aren't very familiar with, especially some of the older ones like myself. But yes, I think, and thanks Wensel for your contribution as well. I think there's a lot of stuff going on in that space, and it's going to move quite quickly going forward. So thanks very much for that.